Okay, welcome and good afternoon to our listeners and those who are joining us via YouTube. This is our fourth episode of the Let's Talk Justice radio program of Jamaicans for Justice. And we are funded, as we always, give our recognition to Open Society Foundation. And this is the show that will tell you about your human rights and explain all the different rights issues that we see coming up in the media. I'm Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, the Policy and Advocacy Specialist at JFJ.
Now, Jade, so as usual, we're going to start out with our segment, just recapping some of the major things that we saw happening in the week. And yesterday, October 10th, was World Day Against Death Penalty. Now, this is a controversial topic, if you will, but JFJ, we're very clear that we're calling on the government of Jamaica to finally remove death penalty from the books, and we support the European Union, the United Nations, and our fellow NGO, Stand Up for Jamaica, who made those calls yesterday, and they hosted a wonderful Twitter space. Did you get a chance to listen in at all?
Briefly, but I did the little that I did hear
in the evening.
Yes, but the little that I did hear was it seemed like it was a very informative little
It
space.
was. It had Casey, Peter Champagny, Carlo Golato, and it was moderated by Jody and Quarry. It was a really good Twitter space. I listened in for most of it, but not all, because TV is being watched in the evenings. Yes.
Absolutely.
And just one more thing I want to point out. September 30th was the day that the country heard the Supreme Court ruling around security officers and their treatment as employees. And that particular court ruling is significant for us. And I think at JFJ, we have always been talking about social and economic rights. And this is a topic that we're going to be talking about in coming weeks. What are those social and economic rights that you have? Not in the Constitution at all. So let us dispel of that assumption that people may have, but certainly there are some laws that really would speak to your employment rights, labor laws.
Absolutely.
Maternity leave, the paternity leave that the government has promised.
Yes.
Has promised.
Yes, has promised. You're right.
Moving from proposing to promise. But the major thing of last week, and I'm going to turn over to you to talk about the right of the day, is the long-awaited Bail Act. I won't talk about if you're out and large and utilize that line, because I don't remember what the minister had said in Parliament when she was doing her presentation then. But I think it's a line that we can, has now become very well known. Out and large, something like that. But the long-awaited Bail Act has been tabled, and it's a bill that will be going to the Joint Select Committee.
Absolutely. So fittingly, our right of the day today is the right to bail. So it is that any person who is awaiting trial in the current state, any person who is awaiting trial detained in custody shall be entitled to bail on reasonable conditions unless there is a sufficient reason to keep them in custody. So when you are arrested under our current provisions, bail is to be considered within 24 hours of your arrest. Yes, so, and I'll just go straight into our trivia question of the day as well, because this week we have a super trivia, just like we have a super topic. So our super trivia for this week is: under the existing Bail Act, bail can be lawfully denied to persons for several reasons. Name 2 valid reasons that authorities may consider to deny bail. So,
sound like a proper UIC question, and the university probably throw that question to us, eh?
Well, it has a fitting price.
Okay.
So normally we are giving out $1,000 credit, but this week we're doubling that, $2,000 credit, and we are also giving out a free T-shirt. JFJ branded, of course. So reach out to us through our social media pages or send us a WhatsApp at 239-7583 and give us your responses. And the first person to respond with 2 valid reasons, correct valid reasons, will receive the prize.
All right, great. So we're just going to be segueing into the conversation of today that will be focusing on the Bail Act. And from our perspective at JFJ, we want to ensure that we are educating the population on the constitutional and human rights implications of this bill and the areas of concern. So, Minister of Legal and Constitutional Affairs Marlene Malahoo Fort tabled the Bail Act in Gordon House on Wednesday, October 5, 2022, and the tabled bill, which seeks to repeal and replace the existing Bail Act of 2000, is set to be reviewed by a joint select committee of the Houses of Parliament.
Correct. The new act has introduced new provisions that may deny bail to an accused person in the case of murder where self-defense does not arise, where the murder is committed in circumstances amounting to capital murder, fitting for death penalty conversation, or takes place within a zone of special operations or in an area where a curfew or state of public emergency has been declared.
The new Bail Act will permit a grant of bail at 3 stages: pre-charge bail, post-charge, and post-conviction in defined cases. The defendant is not to be held in custody longer than 48 hours without bail being considered.
So up from 24. Minister Malahoo Ford also said, noted that the accused is not entitled to bail unless certain conditions are present. She said that this is to ensure that defendants surrender to custody, do not commit an offense while on bail, or interfere with witnesses or otherwise obstruct the course of justice.
The law provides that some conditions may only be imposed by a court, and these include surrender of travel documents, imposition of curfew, and the wearing of electronic bracelet. This is a new provision.
The minister further argued that witnesses are being threatened, murdered, or are themselves part and parcel of criminality, resulting in varying levels of investigative complexities. She further revealed that these and other documented peculiarities in how our Jamaican society necessitates innovative responses legislatively and otherwise.
Human rights must not become a tool for denying security to the public and the state. A balance is required. A balance is required, a sensitive and difficult balance between freedom and dignity of the individual and national security and public safety.
That was Minister Malahoo Fort when she tabled the Bail Act recently. And here to discuss the Bail Act and the constitutional and human rights implications, we're going to be joined by Senator Donna Scott Motley, who is opposition spokesperson on justice and gender affairs, John Clark, who is a board member of JFJ and an attorney at law. Also, we will be joined by Clyde Williams, who is an attorney at law. Do we have all this, the guests with... Senator Scott Motley, good afternoon. Thank you for joining us.
Good afternoon to you, Michael, and to Jade, and thank you for inviting me.
Thank you so much. You heard the last clip. A balance must be struck with human rights and how the government is going about with crime and security and the associated legislation. From the parliamentary opposition perspective, what is your immediate response to such a statement, if you will?
But strangely enough, that is not what struck me. What struck me was the fact that the minister says that human rights must not be used as a tool for denying security to the state. And I focus on that because I believe that in their attempt to abrogate people's rights as a crime-fighting tool, they have gone totally overboard as usual. So there is no need for the state to get in conflict with human rights and human rights organizations. They can pass their legislation in a measured and responsible way, which addresses the human rights of every individual, but provides national security for the citizens. But this constant refrain where they speak of human rights as being an obstacle to national security is what upsets me. And I think it does the society more harm than good.
And that has certainly been a rhetoric, Senator, that we've heard from several public officials in a few years now. I won't say in recent times, because we've heard almost an attack on the judiciary and academia for statements. But is there a specific area of concern within the Bail Act that you believe may be challenging to the human rights of citizens?
Well, it is how they have approached the whole question of bail. Because it seems to me that in a lot of ways they are trampling on the separation of powers. And they are assuming onto themselves the right to deny bail in certain circumstances. The judiciary, you must recall, has always had that right to consider the circumstances and determine whether or not it is appropriate to grant bail. But here now, the Parliament, the legislature, has insinuated itself very strongly into that process. I want to say that when I'm looking at legislation, I first look at the memorandum of objects and reasons.
Yes.
And this particular memorandum of objects and reasons is as confusing as is the legislation in some areas. So let us, if you will permit me, pause and look at that for a moment. May I read it?
1 second, Senator. We are going to take a quick break, and then we would love to get into that discourse with you when we're back. Welcome back to Let's Talk Justice. We are talking about the newly tabled Bail Act. And with us is Senator Donna Scott Motley, Attorney at Law John Clark, and Attorney at Law Clyde Williams. Before we went for the break, Senator Scott Motley mentioned the Memorandum of Objects and Reasons related to the Bail Act, and she had some concerns about how it was constructed. Senator?
Well, let me be very brief now that you have your other guests with you. Hi, John. Hi, Clyde. It says that a decision has been taken to enact legislation to repeal and replace the Bail Act, having regard to the fact that the existing act was enacted prior to the amendments to the Fundamental Rights and Freedoms provision contained in Chapter 3 of the Constitution of Jamaica. The need for new provisions to address circumstances peculiar to Jamaica and the need for greater clarity in certain provisions of the existing act. Mm-hmm. So what it's really speaking to is the fact that we had the Charter of Rights passed after the Bail Act of 2000.
Yes.
But in looking at it, I've not seen a strengthening of the rights of persons. What I've seen is that is an attempt to restrict their rights and restrict the discretion of the judiciary. So that is where I start. That is where I start, that even in the memorandum itself, there is no clarity as to the objectives.
Clyde, I know from your perspective, you have spoken publicly on the challenge that you have had with the matter of pre-charge bail. How do you see the conversation about pre-charge bail possibly infringing on persons' rights? Can you just explain that to the listeners for us?
That's a big infringement. I think that's clause 5 of the Bail Act.
Yes.
Let me back up a little bit. In our jurisprudence, that's a legal philosophy that underpin our laws. We call it jurisprudence. In our jurisprudence, you have 2 categories of persons. You have persons who are arrested and charged. Mm-hmm. And then those persons are to be brought before the court for a bail application. Then there are those persons who are arrested but not charged. Now, if the state arrests someone and does not charge them, those persons are entitled to what is called a habeas corpus, which is an application made to the court for the police to bring that person in custody to the court and to explain to the court why the person is in custody but not charged. This is very significant because until you're charged, you're under the police's jurisdiction.
Yes.
When you're charged, you're under the court's jurisdiction because you have to come back to court. You might get bail or the remand, but you're under the court's jurisdiction. When you are not charged, you're under the police jurisdiction, which is the executive, the government's jurisdiction in that sense. So this bill has, on the face of it, has abolished the habeas corpus, because when you look at Section 5, you see that it is speaking about the police must consider after a certain amount of time must pass, a certain policeman must consider, the superintendent must consider whether or not it should be kept in custody further. And it runs on till about near 7 days could pass or more 6 months, in fact, could pass and you're not charged. I am very concerned about the abolition on the face of it of habeas corpus.
Yes.
Let me add quickly. This bill cannot abolish habeas corpus. So I want to say that categorically, that habeas corpus is not a right that this bill can in fact abolish, because habeas corpus is established in the Constitution of Jamaica. The Constitution says if someone is detained, they must be brought forthwith to, I've forgotten the specific language now, but a court. You cannot keep them away from the court by these measures that they have employed in this new bill. So I want to say categorically that this bill cannot abolish habeas corpus, which is the right of an individual to be brought before the court, for the persons who have held them in custody and detained to answer to the court why they are being detained.
So it may be the very clear indication that it will not pass a constitutional challenge if such is mounted. Or do we get the impression that the fact that this act or the bill has been tabled from the Ministry of Legal and Constitutional Affairs, and the rhetoric that we've been hearing from the government in recent times about the Constitution almost becoming an impediment to crime-fighting measure, I just wonder whether or not these types of provisions that have protected the rights of persons would possibly see some proposed reforms from the government. Granted, we still haven't gotten the legislative agenda on constitutional reform, but that's another conversation to have.
Before I give way to Donna and my friend John, it is very obvious that the government is on a frolic in relation to constitutional rights of Jamaicans. I keep hearing them saying it's how can the Constitution and the laws of the land be an impediment to crime fighting? It's like an oxymoron. It's internally contradictory. They have pretty much lost every single major constitutional action that they have brought. Remember, the minister had come to the parliament and said if somebody get charged for murder, you can't be at large, and that they were going to have a blanket prohibition. Recall, it was the same minister in her first presentation in the 2016 government said that the government was going to set about to abrogate the rights of Jamaicans, and true to form. So I don't believe that this bill will pass the select committee in the manner that it is now drafted. It cannot muster to pass that select committee. And if it does pass the select committee, it will not survive, in my opinion, constitutional challenges.
And, that brings to mind constitutional challenges that we would have seen undertaken in relation to other pieces of legislation the government would have prepared, such as those related to the state of emergency. And I know that Mr. Clark would have been active in several successful cases where persons were held in what would have been an illegal detention. But it seems to me like, the minister did say that it is not so, but it seems to me like the bill is allowing for what again could be an illegal detention, but an extended detention, but this time legally. Mr. Clark, do you have anything to say on that?
Well, ultimately, I've been listening to the conversation, and one of the things that strikes me, especially when the senator makes reference to the memorandum of agreement for this particular bill, is the changes between the Bail Act as promulgated in 2000 and the 2022 version. And one of the most mind-boggling ones, especially bearing in mind that this bill is supposed to expand the rights that the Charter is seeking to do, is the complete abolition of what was Section 22, or what is current Section 22 in the Bail Act, which reads that where a person who is arrested or detained is not charged within 24 hours after such arrest or detention, he shall be brought forthwith before a resident magistrate or JP, who shall order that the person be released or make such order. So that section does not appear as a clause in the bill of 2022. And what one sees, and unfortunately, is that somehow if the bill remains in its current state, is that there will be no real statutory duty on police officers to bring persons detained forward before a judge for the issue of his liberty to be considered. And one wonders whether in a free and democratic society that provision is demonstrably justified. And one look forward to the debate in Parliament, but it is concerning for us on the basis that for the state of public emergency challenge, one of the provisions we relied on was this particular provision, because every single detainee on the state of public emergency had that statutory right. So what the government is doing is, layer by layer, removing all statutory rights that the detainees and other persons may have. And I don't know if one day we'll wake up to see where a person can be detained for a year, 3 years, pending investigation by the police.
But John, I want to pick up there that you're saying, because I can tell you our initial reading of this bill, and Clyde mentioned it earlier, and I think we also did our research internally, and we have seen where pre-charge is allowed in the United Kingdom under its Policing and Crime Act. Now, it suggests to us that we're moving from the court having the powers to grant bail in certain circumstances to now the police. And if you look at the schedule, which indicates some of the provisions or the types of matters that a judge must grant bail, interestingly, the Firearm Act is removed. And then the police in the category of, what's the word, deciding official?
Yes, the deciding
right
official.
throughout the bill, it suggests that the police is now given sweeping powers in the bill to possibly allow for indefinite detention. When you also look at Section 5, subsection 2, and the minister appeared on another program and challenged that there is nothing in the bill that allows for indefinite detention. But when you put everything together and you look at that particular subsection 2 that I mentioned, it certainly gives to the possibility of indefinite detention from our reading and the sweeping powers of the police. We're going to go on the break, John. We're up on a break now, but I just want to pick up with you when we return, and you can give your opinion on what types of powers we possibly may see the police officers having with this particular bill.
Welcome back to Let's Talk Justice. We are live talking about the Bail Act 2022. Mr. Clark, you're about to give us your opinion on the new powers that the police would have under the Act in its current form.
Yes, but before I go on, I was wondering if I could yield to my friend, Senator Motley, and then you can come back to me.
Thank you, John. Well, let me give you my overall opinion of the intention behind this bill. There is no question in my mind that what is being done is to introduce some of the aspects of a state of emergency into the Bail Act. And the indefinite detention is part of this process. I am concerned about a particular and specific reference, for example, to ZOZOs and states of emergencies, which you see in Clause 7. And the exceptions which have been made in a negative way, so that, for example, where a murder is committed within a zone of special operation or a SOE, or in an area which a cordon or a curfew is established, that is taken out and treated in a particular way. I also look at the offenses which are specified that the person can only get bail if they go before the court. And what appears to be a fairly innocuous provision, which is under ZOSO, failure to disclose identity on request, is also one of those that only a judge may grant bail. When you look at bail after conviction, again, that same clause comes under it. And I believe that overall, the intention is to start with the Bail Act to whittle away at the rights of persons, and then to follow by the Enhanced Security Measures Act. So it's an overall strategy.
Yes.
against the Constitution because this administration is very hostile to the Constitution and persons' constitutional rights.
But Senator, I want to pick up there because JFJ has publicly called for the Enhanced Security Measures Act to be made, to be tabled in Parliament, because our reading of the bill certainly gives us that impression. And we do not believe that if the government's intention is to table the Enhanced Security Measures Act, we should be looking at the Bail Act or the bill in isolation. And we agree with you because when you read some of the sections around the review of bail and so on, and John, you can correct me here, but our reading of it seems as if the government has learned some of its lessons, and perhaps it's a good thing, arguably so. When you look at some of the judgment out of the Everton Douglas and the Rasheen Clark and so on, where detention ought to be reviewed every 2 weeks and so on. That language is in the bail bill now, and that was the reason for us, Senator, that it jumped out that perhaps we're looking at the SOE and so on become routine crime fighting measures.
Yes.
So yes. I'm not sure if that was your impression at all.
That is what I am in fact saying, that in inserting it in the way that they have done into the Bail Act, the signal is that they are going to use it as routine crime-fighting tools. And that is why it is particularly important to see what the Enhanced Security Measures Act says, because what you have, I predict, is a whittling away of rights through this legislation, through ordinary legislation, this one, and then the next, the Enhanced Security Measures Act. The public needs to be very, very conscious of this.
Yes. And the danger that we face too is that many persons think that, especially when it comes to bail, that it is quite clear that we're only dealing with criminals, so why then should we care? But issue for bail and the principles that were developed in law were developed because in some instance, you might issue the state of bail, we're not quite sure if the person we're dealing with is an innocent person who was wrongly accused and who could be subjected to very stringent conditions only after 8.5 years in custody, for example, to find that this person was innocent all the time. Mm-hmm. So when we're dealing and we're whittling away persons' rights, we must never forget that we may be whittling away the protections that are there to protect innocent persons who may be wrongly accused.
Yes, and
John, if I may follow up just for a moment, the government is creating a deliberate atmosphere in which they're targeting criminality, they say. So the public joins with them in anything that they do without any discernment as to how far it goes, and without taking into consideration that what you just said, that there are many, many innocent persons who are placed before the court.
There is a Hobbesian principle, however, that in times of war, the rights of man are often forgotten. By Thomas Hobbes, yeah.
Yes.
But yes, we agree.
Yes, and on that line of conversation, we think about the pre-charge provisions and the implications that could have. And Mr. Williams, I don't know if you have encountered, as an attorney, have you encountered any client that even after being charged, they were innocent? And were
Holy. I mean, most of my career at the criminal defense bar, most of the cases I've done, persons were found not guilty. Remember, our jurisprudence is not to determine if the person is innocent. Our jurisprudence is saying the person has not been found guilty. And that is very important for us to understand.
What I consider though is how pre-charge affects the presumption of innocence, because if you are being considered for bail, you have not even been charged with anything. What does that say about your presumption of innocence?
But can I counter you before you answer, Clyde, please?
Yeah.
Because the pre-charge bail, based on some persons, say the crime rate is high and the victims ought to be protected. So when we look at the conditions of bail, for example, and its intention of protecting the witness, granted I don't necessarily believe this, I'm just putting forward what the public is saying in an attempt of being balanced, that it allows for the victims to be protected and so on. The presumption of innocence, shouldn't that be balanced with the victim's rights so to speak?
All right. I don't waffle on these rights. History has shown us that if you waffle on these rights, you end up the next morning without any. So the Bail Act cannot solve and contain the criminality that is let loose in the country. So I want us to be very clear about this. This Bail Act, and whatever form it wants to take, cannot contain criminality. That is constrained through police investigations, thorough cases being built, and high rates of conviction. I want to go to the constitutional provision on habeas corpus. This is very important. This is section 14 of the Constitution, 14 subsection 3 of the Constitution of Jamaica. And it says, any person who is arrested or detained shall be entitled to be tried within a reasonable time. And A, so the person who is arrested and detained shall be tried in a reasonable time. And A shall be brought forthwith as soon as is reasonably practicable before an officer authorized by law or a court. This is the stage that the government, what they call them, authorized officers, I've forgotten the name of they use in the legislation. Somebody help me where they said they brought these people.
A deciding official.
Yes, a deciding official.
Deciding official. So they're making, so the deciding official is part of it. So it says brought forthwith or as soon as is reasonably practicable before an officer authorized by law. So in this case, it will be the deciding official. And then it says, and released either unconditionally or upon reasonable conditions to secure his attendance at the trial or at any other stage of the proceedings, because the person may not be charged. And B says, if he's not released, as mentioned in paragraph A2 that I read a while ago, shall be promptly brought before a court, which may thereupon release him as provided in that paragraph. When I looked at the pre-charge position in the bill, up to 5 days could pass, up to 7 days actually, because if they can't charge you, they say they can't charge you for whatever reason, they can't charge you, and you have to face an ID parade, 5 days they are allowed. And then after that, now a superintendent must make a determination above the superintendent and above must make a determination as to whether you ought to be released. And that determination, another 48 hours could pass before that determination. So we're at 7 days. And then you're brought to the court. So what this bill is doing is entrenching and putting in law the corrupt practice that exists in the police right now, in the JSF, of holding boys in detention for days on end without charge and without bringing them to the court.
And interestingly, Clyde, I heard statements publicly that given this thing is a practice of the JCF, we welcome the bail bill. And my immediate response was that we're legitimizing illegal actions of the state to begin with. So I'm happy you said it, because I found it offensive that such a utterance would have been made to say that, okay, people don't normally get released on bail within 24 hours anyway, so the 48 hours is certainly welcome. People don't normally be released and lock up and so on, so therefore this is welcome. So I'm happy you put that in perspective, certainly.
What about
this is very so go ahead, John.
I was wondering, what do we think about the 120 hours that persons will have after arrest or detention if ID parade is required?
A wickedness, that's the 5 days. John, you know this what they did in the legislation. I hate when they do these things. Them try hide it, say it's 5 days. Them put 120 hours. So you have to know, stop the workout. How many days this? So why would they use days and then switch to 120 hours? Put 5 days. Make we know say it's a week you want to lock up the youth them for. So here's what. My first matter as a young lawyer in 96, I won't forget it. A young boy gets arrested by the police, no charge, and the police moving from station to station to avoid the habeas corpus application. Station to by the time we serve papers from one station, they say no did they. Sorry to use that kind of language, you know, extreme Jamaican on the radio here. But that's how it felt to me. That's how Jamaicans see it. And they kept moving the boy around, and eventually we found him and he was released. the government has selectively used statistics by saying people commit crimes on bail when they are charged. But the government doesn't tell us how many persons who are charged for serious offense get convicted.
Yes.
So if you have 100 persons charged for serious offenses and you only have a conviction of 20 of them, which is what is going on roughly in Jamaica, about 20% for offenses like murder and so on, which means 80% of the people who you had detained were innocent. Sorry, not innocent. There wasn't sufficient
evidence, right,
to convict them.
So we have to wrap up now, Clyde. So I'm going to give you 30 more seconds to give us your final word, and then the senator, and then John.
Yes. Well, no, you see, we have to go and make John go first, then me second, and the senator last. Seniority at the bar. So, John, you're up. You're up, John.
Well, all I have to say, I look forward to the public discourse on this issue. And that's it for me.
Well, for me, I'm looking forward to challenging one of these laws if it musters through the parliament. That's what I'm waiting for. I'm waiting for to challenge one of them, because we must put a stop to this unconstitutionality that the government has overwhelmed the Jamaican people with.
Yes.
I want to make 2 quick points. Firstly, I want to commend the government for putting it immediately to a joint select committee without having to be asked. And secondly, I want to say to your public that even now, judges, from I entered practice, judges have been making orders and conditions of bail which protect the public and protect the victim. So, for example, they will say, you do not return to this community. You must report to the a particular station twice per week. And other conditions which take into account how the public feel and how the victim will feel. This is not new. This is judicial discretion at work. Yes. And I encourage everybody to recognize that our judges do consider the opinions and the safety of the public.
Absolutely.
Right. Thank you so much. That was Senator Donna Scott Motley, John Clark, and Clyde Williams. Thank you so much, lady and gentlemen. We're going to go on a break.
Blessed Lord.
Welcome back to Let's Talk Justice. Today we have been discussing the Bail Act, and we are now at the part in the program where we are able to take calls and comments from persons. So if you are interested in participating in the show, sharing your opinion, you can call us at 876-676-4996, or you can send us a WhatsApp at 876-239-7583. And in light of public opinion, I want to mention our public view that is posted every week on our Instagram and Twitter pages, where you can go ahead and share your opinion on what would be the topic for the coming show. So this week's public view, we asked, what is the understanding of the new Bail Act that we've been discussing today? And the general consensus we've been receiving in our social media platforms, in our WhatsApp, is that there is no understanding. Some persons are concerned, Mikel, about why the Bail Act was changed in the first place. They're unsure as to what was the problem with the original Bail Act.
You know, I've and you know this, because when the bill was tabled, I did not go to bed until 1 a.m.
Yes.
And I literally had the 2 pieces of documents up, trying to ascertain the differences. And some of the differences are upsetting,
yes,
if you will, because this issue of the pre-charge bail is clearly why the government saw it fit to repeal an entire piece of legislation. And then a lot of the points in terms of the conditions of bail, they repeat. But there are some upsetting areas that were introduced. So, for example, I can be denied bail based on misconduct. You flag that as an area.
Yeah, because what is that? The conduct of the person. Who determines what is...
So if I shout...
But I don't know.
Because I'm upset.
I don't know.
And then the area that you live, apparently, you can be denied bail. So if there is an SOE, for example, and I live in that particular area, and you accuse me of a crime, you don't have any evidence whatsoever, But the fact that I am from that particular community, you're telling me that a piece of legislation being proposed by the government will see me denied
It
bail.
goes even further because the condition is not whether or not you're in a community that has that is currently under emergency powers conditions. It is that you can be from a community that is known for a certain kind of crime.
Exactly.
So myself from Montego Bay here, I might be denied bail on the basis
Well, I'm from
that
St. Anne. We don't normally have certain crime down there.
but I might be denied bail on the basis that there is a large number of scammers in that
Yes.
area.
Yeah.
And so, on the basis that I may be possibly involved, I cannot get
There are
bail.
many things, Jade, and I've also made it a point of duty to review the UK provisions, which certainly it suggests that that is what the government perhaps had looked to for an example. But interestingly enough, the UK made certain changes to their own legislation to prevent some of the possible injustices from happening. And by the way, it's still challenging because they have this nonsense called released under investigation, which can give rise to another set of issues.
Wow.
But say, for example, I have been accused by the officers under Section 5 with this pre-charge bail, yes? And they want to release me on bail with certain conditions. Remember, I have not yet been charged with anything.
Correct.
But they release me on bail. What the reading of Section 5 suggests is that the police can put you under certain conditions, such as placing you under curfew, restricting your freedom of movement, who you can associate with, for 6 months. But it doesn't stop there now, because before that 6 months elapse, it then suggests that another 6 months could be applied
Hold a
for.
second. Okay. So the reading of the bill is that once you are this pre-charge bail, the bail
Yes.
you are given when you have not been charged with a crime, is a bail that you can get for as long as 6 months and can be extended for a further 6 months.
Yes.
So you can be on bail conditions,
For up to a year.
which can be strenuous, can involve reporting to the police station, can involve taking your documents, can involve telling you you're under curfew.
If the police need more time to investigate. But
Wow.
what is interesting is that there's nothing in the bill, based on my own reading, that suggests that the police must. There's something about submitting a report, but it doesn't outline the content of what must be in that report. For example, what is the status of the investigation? How is it progressing? Is there reasonable cause to say that I must be on bail condition for this particular period?
Well, Michael, I don't think there's reasonable cause to be on bail condition regardless because you are not charged. But before we run out of time, I think we have someone on the line. Michael, are you there?
Yes, good.
Somebody has my name?
Well, I would say you have my name.
No, you have mine. It depends on our age. But go ahead. Good afternoon.
Well, yeah, okay. So, well, I'm actually here just to keep up the good work as it relates to informing the public on the matters arising from human rights. But I am also taken aback by the particular proposed piece of legislation,
Yes.
a proposed bill. I've realized that we in this country have a tendency not to care too much about human rights, and that's straight across the board. And I have been disheartened time and time again by the current Minister of Constitutional Reform and whatnot. By her insistence on putting certain pieces of legislation forward that undoubtedly will be struck down by the courts.
Yes.
It's sort of telling the inner workings of some of our elected officials. So
Yes.
that's all I have to say on the matter.
But I'm happy that you call Mikkel, my namesake, if you will, because I think as citizens, we have to keep abreast with what is happening. And I think collectively we must ask the government to clearly indicate the legislative agenda of the Ministry of Legal and Constitutional Affairs, because there are concerns about the types of proposals that are coming up. And the ones that we had expected to be proposed to the country, we haven't yet heard anything, such as the process and the roadmap for getting rid of the monarchy, for example. Where is that Constitutional Reform Committee? What are the types of reforms that we can expect outside of the trampling of human rights as we have seen coming up. And that is my immediate feedback, and I would just urge the government to perhaps respond in kind to so that we're assured that while they fight crime, they're doing so in a way that respect the supreme law of the country.
Yes, thank you so much.
You have a good day.
Take care. Bye-bye.
All right. We've been seeing some comments. We urged Lloyd D. Smith to call, and I just want to indicate what he said in our YouTube chat. He was in agreement with Mr. Clyde Williams in terms of what is reasonable, that we're allowing the police to breach our rights and put that into law as legal. And he indicated that he was also arrested unlawfully in Halfway Tree on a Friday, and the officers deliberately ignored his request to go before a justice of the peace or judge before the day was finished.
Yes, that is actually one of the things that many practicing attorneys, myself included, would have seen is persons are deliberately arrested on a Friday so that the option to be given bail that's not station bail is not available to them until the following week. Before we close out the show, I want to say that we do have a winner for our trivia question today, which was a super trivia. So Tricia Williams has won $2,000 credit and a JFJ t-shirt, and that could be you next week. The response that she gave, the question was 2 grounds on which bail may be refused, and she responded to say that the person could have more than one offense. So you are a repeat offender, that is a basis on which bail may be refused, and another basis is if the accused is considered a flight risk. So that means someone that is likely to leave the country. So Tricia, congratulations, and the team will be out to you to
Is it Tricia or Trisha?
I'm sorry. I thought it was Tricia.
That sounds just very uptown, Jade, but it's fine.
Okay, so we'll be in touch with you to let you get your prize. Thank you so much for participating, and those listening who felt like they missed out, know that you can participate in next week's show, and you can look out on our social media pages for how you can do that.
All right, thanks again. I'm Mikkel Jackson, JFJ's Executive Director.
And I'm Jade Williams, Policy and Advocacy Specialist. We'll see you next week, same time.